Welcome back to another episode of Divorce at Altitude. This is Ryan Kalamaya. This week, we're going to be talking about divorce and real estate. There's been a lot of discussion in the news at the time of the recording about real estate and home prices. We've had several episodes in the past, but we are joined by our guest. I'm going to introduce her or let her introduce herself, Karla Kyte, to talk about the common misperceptions and really get to the heart of why didn't my attorney tell me this? And I'll let her explain more, but I think this is going to be an informative, meaty episode. So I look forward to conversation. But Karla, before I go on, welcome to the show.
Thank you. And thank you for allowing me to be in this space because I wish I could scream from a mountaintop everything that I know. There's just so much.
Indeed, we've got the time and we won't be screaming. So if you're listening out walking the dog or in your car, but I think the point is that it's that important, and it happens. So before we started recording, we talked about a couple different examples and real estate, and in particular residential real estate, the marital home, that it comes up in nearly every divorce. But before we really get into the first topic, which is child support and maintenance and how those kind of relate to real estate, Karla, can you give our listeners a little bit of background on who you are and what experience you have that would result in you shouting from the mountaintop?
Yeah, absolutely. Thanks. So I have been a lender in Colorado, specifically in the Denver area, for over 27 years. I did my certification, which I'm a CDLP, which stands for Certified Divorce Lending Professional. And I did that back in 2017. And to be honest with you, prior to that, I would always I couldn't figure out why we were not included in the settlement process. Like, why wouldn't you reach out to a lender and ask how to put this together properly so that it can actually be executed afterwards? When I heard about the CDLP, I actually flew down to Arizona for a couple of days to get the certification. And since then, we're a high volume team. So I just have a ton of experience, and I was able to bring my daughter on as a business partner about 5 years ago. And she is also a CDLP, but she's only 30. So she's not really her jam, but it's allowed me to really step aside. And I now have my own fee-based divorce mortgage planning business that I run separate from the lending side. There's a huge need for people to do proper divorce mortgage planning during the settlement phase before they all agree on something that, oh, we can't do this. And so I see that time and time again.
Yeah, and I see time and time again, people, even when I have the discussion of you're going to need to refinance or figure out the financing, they'll look at me, Eric and Melanie Wolf, our hypothetical divorce clients, and they'll say, really? What? Because at the time of this recording, mortgage rates are in excess of 6%. And a lot of people, when you were cutting your teeth on the licensure, people were locking in the 3 and 4% mortgages. And so they're shocked that they have to go through this whole process. So let's jump right in. The first topic that we have, talk to me about child support and maintenance and how that matters from a home buying perspective.
Yeah. So the simple answer is really you have to have received the support. You have to have a court order and receive the support for, depending on the loan, either 3 or 6 months. And then at the time of closing on the loan, the support has to continue for 3 years. And I say that these are different loan types because FHA and VA, you only have to receive for 3 months, whereas conforming, you have to receive for 6 months. The problem is that if you have a client that is only receiving support for 4 years, they have a 6-month window where they can actually complete a purchase transaction or a refi transaction.
So that window then can be complicated if there's some sort of property payment in a year that they were going to rely on for the down payment of a new house or that sort of scenario. And people, I think, are naive. You and I were talking before the show. I had a mediation 2 days ago, and the other side, the recipient, of spousal maintenance said, we were negotiating a buyout and there was a request for a year. And it was like, I need to have a year of payments. And she was working with some lender, or at least that was what the mediator said.
Mm.
You're shaking your head because, and I did the same thing. I was like, why a year? Like, it's got to be at least longer. Every banker I've ever talked to has said that they need longer than a year. And you and I were talking before the show that I was not crazy. So the kind of rule is 3 years.
Yeah. And so that's part of the problem, though, is that people are getting information from people that don't understand exactly what's going on with them. And I hear this time and time again. And so a CDLP is one step closer to getting the best information,
Mhm.
but sitting down with somebody like myself that actually does this on a day in, day out basis and will spend the time to help them plan properly is really what they need to do. They get bad information from their current servicers. They get bad information from their current loan officers. And some loan officers know some of this business, but I would say most of them don't know a lot of the details that we get into. So there's like certain things we could do with your client there. We could have the maintenance go longer. We can pull from something else and turn it into maintenance. We can set up some different accounts. There's a lot of different things that we can do if we're involved in that planning stage.
Yeah, to be clear, my client was the one that was paying it. We had there was a $100,000 payment, and we said instead of a year and 100,000, we'll give it to you over 3 years. And it was the same kind of net present value, and they said no, but it would have bet it. And we were like, "This aren't you? Don't you want this? Because this shows the bank." And I knew enough to. We weren't the ones that my client didn't need the loan, but that was an offer, and I thought it was somewhat of a fumble by that side or that attorney. That is just an example. I think it's just something that you see and I see, with a fair amount of regularity. Carla, can you maybe talk a little bit about the difference between child support, spousal maintenance, and in particular, because we've had podcast episodes, there's a how-to episode on the difference between contractual maintenance versus modifiable maintenance. Child support is always modifiable. Maybe talk to me about whether that matters. If you have contractual maintenance of 5 years or 3 years, the minimum, and is that different as opposed to child support of the same amount for 3 years? But the kind of punchline is that child support could change in a year. Does the bank really care?
If it is specified, we see a lot of maintenance that is gradual, right? So they might start out at 5 grand a month and go down to two and then down to, 1,000, whatever.
Mhm.
So we will only use that lower amount. So when we're talking about anything like that with maintenance. With child support, it's when the child ages out of support, which is typically 19,
Mhm.
unless otherwise stated. If we're dealing with child support and the child is already 16, we can't use a dime of that. Because again, they have to have received it for 6 months and it has to continue for three. Any support that is less than 3 years and 7 months would not be usable at all whatsoever.
And for listeners, I've been doing this long enough that maintenance, spousal maintenance, alimony, it used to be tax deductible for the payor, and it was taxable income for the recipient. And so there were circumstances where we could do this tax arbitrage where Eric Wolf would pay Melanie, for example, $10,000 a month. He would be able to deduct that. So his net cost was $7,000 because he's at a 30% tax rate. Melanie, on the other hand, she's the recipient, but she's in a substantially lower tax bracket. So her net benefit would be more like 8,500. And so we would really lean into this and we would do it. So we'd have these significant maintenance and child support, in essence, awards, but they would be packaged into a spousal maintenance award because they were looking at the whole month cash flow. And it sounds like what I'm hearing you say in that example of the 16-year-old, that the parties might agree that spousal maintenance, and they characterize it as spousal maintenance for a particular time period that is beyond the 19 to help Melanie qualify for a loan, even though it's really child support?
Y- yes. And you actually just touched on something else I want to touch on if I can. I know this is a little bit off topic, but first of all, so we could extend the child support, right? I
Right.
think that's okay. You guys could, if you could even just
You
extend it
can.
a couple of months and you could lower that amount a little bit. But the whole thing with the taxes, okay? The cool thing for the payer, and this is okay, so this is a Fannie Mae guideline that I will tell you not many lenders have any idea about this. But when we're going to qualify the payer of the maintenance, under Fannie Mae guidelines, we can deduct that from their income basis instead of hitting them with that as a monthly debt. And it helps them qualify. I have some examples when I'm teaching CE to realtors and CLE to attorneys. I have some examples that would absolutely blow your mind. It goes from not qualifying at all to being able to qualify for, a $700,000 loan.
So what I hear you say is that how the payment is characterized, both in terms of spousal maintenance and child support, having a lender or someone like you consult can matter not just for Melanie Wolf, who is the recipient, if you characterize it for the payor in a particular manner, that may matter if Eric in a year, 2 years, wants to qualify for a mortgage himself.
Or maybe he's refinancing the marital home and keeping the marital home. I've helped people figure it out so they can both remain in homeownership. That is my goal.
Yep.
And often I work with both parties because if I can work with both of them, I can help them figure this out and find that sweet spot where they can both qualify because
Mhm.
we can count that income coming from Eric for her. And we can also gross up child support. Since we're on the tax thing here, we can gross up child support too, coming to her. But we can deduct that maintenance in a different way that hits him less in his debt to income ratio, allowing him to qualify for more.
Okay. And that is a good segue into the next topic, and that's temporary support. And you mentioned in your intro or at the beginning of the show about the payments during the divorce and how that can matter for qualifying. And I know enough to be dangerous about this. I don't pretend to be an expert, but you are the expert. So tell me, what does child support and maintenance on it for temporary orders, how does that matter?
So it starts that 6-month clock ticking, which is huge. I literally just got off of a call with a lady earlier today who I found out we have to have the court order in place. So the temporary order has to be in place and they have to be making the payments on time. You have to be able to prove that. So what I learned in my phone call is that she's been getting payments on time since October. Now, the temporary support payment that she's receiving now is only 2 grand a month, but she is expecting 5,000 a month for her permanent orders, which is fine because as soon as that permanent order goes into place and we've had a 6-month track record of him paying the 2,000 a month, we can use that 5 grand a month as soon as he makes that first $5,000 payment to her. And that's exactly what she needs to qualify.
So what I'm hearing you say is that there's a clock, it's 6 months. You need a court order. It starts from that order or that first payment, and that you can grandfather in to the first payment even if the payment changes
Yep.
later on, and use whatever that higher payment is. Because and I've talked about this on other episodes. I tend to fall into the camp of, if it's all marital property, and so Eric and Melanie Wolf, if Eric is living in the marital house and Melanie's living in the kind of rental place, or vice versa, that the kind of payments that are being made are coming out of the marital account, and that we shouldn't really litigate and position and posture about, should Eric pay Melanie $10,000 a month or $5,000 a month, when we don't really know a lot about his income or her income and whatnot. But your example is that it really can matter, and it may be worthwhile for Melanie to receive or agree to a lower amount that Eric might be more comfortable, obviously, agreeing to just to start that clock.
Yeah. And the example is, and I had a handful of clients over 2024 that had to take different loan programs because they couldn't get the temporary order put in place.
Mm,
And it's really unfortunate because I know in a couple of those cases, they were amicable enough that could have happened.
mhm.
But for whatever reason, the attorney would not put the temporary orders in place. For example, one client that I'm thinking of right now, she was forced to put down 25%, which she didn't, she wanted to only put down 20%. But she had to put down 25%, and the interest rate that she took was almost a full point higher than what she could have had she had temporary orders put in place. It just is helping them be in a better position. And I know if the couple is, if they're amicable enough, I know it's just a stipulation for you guys to put that in place, right?
It is, and the risk is that the posturing is that Eric and Melanie, that if they agree to $2,000 a month, Eric is gonna say, "That's too high," or Melanie might be like, "That's too low." We can there are stipulations where you can state it's $2,000 a month, and this is the court cannot consider it if the court later determines it's $5,000 a month, and it should have been $5,000 a month at the very beginning, that there's a true up, that or that if it's too much, that it can be credited or offset against future kind of obligations. But if the goal is, for example, for Eric to go buy a house, they have kids, and they really are, that's where they're really trying to provide stability, and the
Yeah.
housing, it becomes paramount, that in those circumstances, it might be beneficial for them to at least agree to some placeholder amount that is somewhere in the middle, and that it really just to start that process, because they might be paying a point and putting substantially more down to begin with.
Like, I'll be honest with you, I don't even care if they are paying that money and throwing it back into some joint account down in all
Yeah.
honesty. I have to show proof that it's been paid or received. And that's what we're looking for.
Okay.
So obviously this doesn't work if they're not amicable enough to figure that.
And it also, if Eric and Melanie, if they have a joint account, everything's been coming out of that joint account. This kind of presupposes not only do you have a temporary order, but you also have an Eric and Melanie separate account, or at least Melanie, if she's the recipient, she needs to go to the bank, create her own account that she then shows deposits into, and that's pursuant to a court order that is temporary support.
Yes. Yeah. And that's a really good point because it does have to come from individual to an individual account. It cannot be funneled between joint accounts.
Oh, okay. That's
Just temporary
I
workers.
I didn't know that, so that
Yeah.
is helpful for me to know. It's one of those things that the balancing act of, and Carla, you see this, right? Where you're working with people, you have solutions, and but also people, they're so emotionally, like, Melanie might be just completely destroyed emotionally because
Mhm.
Eric's having an affair, and she's just used the credit card. She's never had to go do things on her own. She's just gonna bury her head in the sand, and she just can't deal with it. But it's more of, it's important to explain to her at the appropriate time that, hey, you need to start getting a bank account set up and working with someone like you to explain why that's so important.
Yeah. And those are the people I just want to grab and go, just stay with me. Just stay focused. We're going to get through this. Yeah.
Agreed. It's one of those things that it's that I can see where it's going, and I can explain why it's important, but also at the same time, I've also seen people where they're just emotionally they are incapable,
Yeah.
and that's the moving on. For the people that are really hot to trot and they want to go buy a house before the divorce is even final. Talk to me about how can you buy a house before the divorce is final? Is that
Yep.
even a thing?
So we do it all the time. It does take a specific divorce type, right? They need to be amicable. They need to have the approval from their attorneys. Of course, if they have both retained attorneys, we need approval from the attorneys, but it's very possible. So what we need to move forward in that space is we need a court stamped separation agreement. And for consumers that are listening to this, that's because we need to know who's paying who, what, how much, how you're dividing everything, right? Because that's the only way that we can actually qualify you for a loan.
Mhm.
But we do not make you wait for final decree. We know that divorces are handled very differently by everyone. And so a lot of times they have everything figured out and then they file, and then there's this 90-day waiting period. And it's a long wait. I've been through a divorce, so I get it. Even when you're amicable, being in the house, especially with the children, it's no fun. You're getting divorced for a reason. So if we can help them move on without waiting for that final decree, that's really our goal. It saves them money, it saves them time. Sometimes we'll be really strategic with the separation agreement. Like if they can't qualify for that new home loan with the current mortgage against them, all you have to do in the separation agreement is award that payment to the one spouse. And then that takes it off of the other spouse's debt, and we won't count it against them. So that's a big misconception that I've heard from several attorneys, and a lot of lenders think that you have to show proof that one person has made the mortgage payment for 12 months before you cannot count it against the other person. It's not true. As soon as you have a court stamped separation agreement, we will not count any of the debt against the person that it's been not awarded to. Does that
Okay,
make
so
sense?
then, yeah, I've got a couple kind of follow-up questions on that. So, I recently had a case where the parties were both renting. They had sold their house in anticipation of the divorce, and then my client identified a house that he wanted to buy. So we agreed that he would get they were sitting on a ton of cash, and it was gonna be equally divided. So he said, I'm gonna take my 200 I'm gonna take $250,000, and that's gonna be in advance on what I'm gonna ultimately get. We're still figuring out a couple other things. And so he got the $250,000 that was used for the down payment, and it was in the middle of the divorce, so we basically had a partial separation agreement, or an agreement that the $250,000 was his, and that he was authorized to use it for his house. And then what we agreed to ultimately is that the cost of the house, because he had 250 for the down payment, but then he also had some closing costs that were like
Mhm.
$15,000. So that went in on his side of the ledger when it came to the ultimate reckoning. And so we had a stipulation, and he was able to purchase that residence through in the middle of the divorce. Is that something that that you've seen?
So that's not typically what I see. That to me was more of a legal issue,
Mhm.
right? Because from a lender's perspective, we, the lender on that transaction maybe was not even made aware that there was a divorce in process. So if they were in that situation where they were renting, because as a married person, I can go out and buy a house in just my name. I don't have to
Right.
have my husband on it. So he maybe just did it like that, which is totally fine. Typically, there's still a marital home. So there's a mortgage in question, right? And so that's where it becomes a lender issue, is because then we're wondering, well, what's going on now with this mortgage? And that brings up is there a divorce going on? So
Right.
once the underwriter knows that there is a divorce, that triggers the request for the court stamped separation agreement.
Right. So
So,
another, and that was gonna be my next example, is that if Melanie is gonna get the house, there is an agreement, that she gets the house, she's gonna take the mortgage, and they have enough cash where Eric, kind of same scenario, instead of renting, but Melanie, she's gonna get the house, and we have a court order, and it could be that she's gonna get the house, and in exchange, Eric's gonna get an advance or some particular amount of money. If he comes to you and says, I've been authorized, I got the green light, I've got money to go buy a house, then the fact that there's an agreement that says Melanie is taking the house with the mortgage, that's the key magic language that you need to let him proceed, even though there might be a business, there might be other things that could be outstanding in the divorce, parenting, they could be just in disagreement about child support or other things. But the key thing for you is that you need to see that Melanie is getting the house and the mortgage, which then removes that issue for him in terms of the debt to income ratio and the qualification that would otherwise jam him up on the mortgage. Is that right?
That is right for the mortgage, but we still need everything else figured out
Oh,
because
okay.
we can't approve the mortgage not knowing how the support is going to be paid.
Okay. So you
We don't,
can't you
yeah, we
couldn't
don't care as
yeah.
much. Yes.
Okay, that
What you were talking about, like getting that mortgage off of his debt, yes, that would take care of that. But that's still without having a full. And here's the thing, and this is why I think a lot of lenders and underwriters will not do this without a final decree, because we know that even though we are provided a court stamped separation agreement, we know until final decree, there can still be changes made to that. So don't ask me why. We are totally fine using that to close a loan with, even though I know it can still be modified for whatever reason. Underwriting is okay with that. But I will tell you, some lenders are not okay with that and they need final decree.
right.
But yes, we do need, absolutely, we have to have the child support, maintenance, everything figured out before we can close.
The cardinal rule for me is that people that want to go out and buy real estate when the things are just in such a state of flux. I hear that so much. I want to go buy a place. And I'm like, really? Do you really like there's nothing wrong with renting for a little bit to let the dust settle. And so the finality that the lenders want is consistent with at least some of the discussions that I have with clients who are just really wanting to go out and buy something. But when they eventually are ready, then they should make sure that they're doing it during the divorce process. I think one of the key headline news items from this episode is that they should involve someone like you if they're thinking about buying something in a year or 2 years, or they should just there's really no downside to engaging someone like you to make sure that there's no unintended consequences.
Yeah, for sure. If they own a home or they ever plan on owning a home, they should absolutely have a CDLP involved in the process for sure. And especially because rates are so high right now, I'm not just setting my client up for purchasing a new home at a decree or whatever. I'm making sure that they're set up to refinance too, because if it's a stay at home mom that is re entering the workforce, we're planning this all the way out. We're not just planning out to purchase, we're planning it all the way out. Is she going to be in a career that will allow her to qualify in a year or two when the rates are lower and she can refi? This is the last person that I want to miss out on a refinance. So they need it more than anybody.
Absolutely. Let's switch gears and talk about assumption of loans. So this is
Ooh.
something I hear a lot about, but
Yeah.
don't see it actually happening in practice. So disabuse me of my skepticism on
So
assumption of loans.
first of all, let me say that almost everybody has a very low rate that's going through a divorce. I'm shocked when I hear somebody that says they have a rate over 5%. So almost everybody is in a low rate loan because almost everybody refinanced during the COVID years for these
Mhm.
low rates. And now they're finding themselves in a divorce. So the biggest thing with the whole assumption process is, and I hear this all the time, even from clients of mine, they'll say, I called my servicer and they said my loan's not assumable. And I'll say, did you tell them that you're going through a divorce? No. I've actually had some people tell me, no, my attorney told me not to disclose that. So the problem is that, yes, they have a Fannie Mae or a Freddie Mac loan. Those are not assumable loans. But in the case of a divorce, they will allow a release of liability, which is an assumption. So they just have to ask the right question.
Got it.
They have to disclose that they are going through a divorce. And even then, they still might get told no. And I
Right.
say, call them back. Like literally, call them back 3 times. I'll get on the phone with you if you're not getting the right answer. They are assumable. The next problem is that really the smartest thing to do? And we can talk about that. Or do they qualify? Because just because it's allowed doesn't mean it's going to happen. People think that just because they pay their mortgage on time, that they can assume the loan. Not the case. They have to fully requalify.
Let's take a step back because I jumped the gun. What does assumption of loan? What does that mean? So, like for Melanie, what does that mean? Eric and Melanie have a house in Boulder. They have a loan. It's a joint loan or joint mortgage. What does it mean for Melanie to assume that loan?
So Melanie will be able to take over the loan and release Eric of liability of that loan in its current state. Same interest rate, same loan amount, same everything. So she won't be able to use that to buy Eric out. So if she owes Eric $300,000 from the equity of the home, she's going to have to find another way to pay him that. HELOC, family money, investments, whatever. She can find a different way to pay him if she assumes the loan. That's why it doesn't always make sense, because sometimes if you're just looking at it from a cash flow perspective, it makes more sense just to pull an actual refi so that you can put that into the new loan, the buyout amount.
And that kind of leads us into the next topic, and that's paying out equity or off buying out a spouse of equity in the house. In contrast to the assumption of the loan, so if Melanie wants to avail herself of that 3% interest rate, she assumes the loan, she qualifies. She's keeping the $500,000 mortgage as it currently is, but she can't go and get a $800,000 loan at the same interest rate that they had at the COVID. She's going to have to refinance and pull out, and she may be able to do that. But I guess with the assumption definition in mind, walk us through the paying out equity and the refi, those topics.
Yep. So the other thing to know is that there are different kinds of refinances that we can do for divorcing clients. Let's start here. If she assumes the loan, she can do a home equity line of credit to pay him out. She can do a refinance. Most lenders would do this as a cash out refinance, which carries higher fees, higher interest rates, and you're capped at 80% of the value of your home.
Mm.
Most CDLPs should know this, but there's something called a buyout refinance, where the refinance is only used to refi the current loan and pay off the ex-spouse. You cannot pull out one penny more than that. That money goes directly from the title company at the time of funding to the ex-spouse.
Is the benefit that it sounds like that's a specific product with kind of regulations and guidance and everything. Is the benefit that it's a lower rate than just a normal refinance?
It's a little bit lower than a cash out refinance.
Okay.
Right. But it's like not a special program. It's a Fannie Mae, Freddie Mac program that lenders just don't know exists.
Okay. But
So
it does result in so if the real intent, if Melanie is just razor thin, she can't take out additional money for the bathroom remodel or for, her post divorce escape to Thailand, she has to use all the money, but it is going to result in a lower rate, which is overall beneficial, especially when you're talking about 20, 30 years. And she needs to know that, and it's not really common knowledge. Got it. So are you that real estate, the key mistakes buyers make during home purchases?
just during this process, yeah, from a lending perspective, but not from a real estate. Yeah.
Okay. Yeah,
Real estate
this was
agents
just in
get
the
real
outline.
touchy.
So we'll cut
That's
this whole
fine.
thing. Okay, we'll go back on. Okay, so Carla, let's wrap things up. Let's finish with the common mistakes that you see. We've talked about several of them, but what are the things that we haven't talked about or covered that you commonly see people make mistakes on?
Yeah. So first of all, I hear a lot of, why didn't my attorney tell me this? And I remind them that their attorney is not a lender and it's not your job, right? Your job is to legally separate them and take care of their business that way. but your job is not to see them through a refinance. So the common mistakes that I see is just simply that people agree to a settlement that they can't execute after decree. And that this literally happens. I bet you on an average, talk to one or two people a day. So it happens often. If they could figure this out before, it would save them time, money, having to go back and modify. And then a lot of people can't even go back and modify their agreement because the ex-spouse won't meet them at the table for that. So I see a lot of common mistakes. Obviously, when people are pro se and they have no representation, there's a lot of problems there. I would say probably the biggest problem also is as an attorney, when you tell them, well, make sure that you qualify, but they're not calling the right people. Like they're calling their servicer or they're calling their old lender, and their old lender maybe they'll quickly look up a guideline and say, yeah, you can do this. And they just get misinformation. So they agree to something in that settlement and then they're forced to sell. I talked to a lady yesterday who she was on quite a rant because her kids came home and told her they were upset with her because dad now had to sell the marital home because he didn't qualify to refinance and pay her out. And she didn't understand how that was possible because they had qualified previously for a mortgage.
Mhm.
And she goes, I don't know if he has more debt. He has student loans. I don't know if those are stopping him. But those are some of the problems. We have things that change in our guidelines. Like we had massive student loan guidelines that changed about a year ago. And maybe they did take out a loan just fine 2 or 3 years ago. But today the guideline has changed and he no longer qualifies. And so now the kids are upset with her because he can't refinance and he's going to have to sell their home. Hopefully I can get in with them and we can try to modify something but it's just mistakes like that. I see when people are really amicable, they don't follow court orders. So we might spend a lot of time putting something in place that works for them and it's a great plan. But because they're so amicable, Eric will maybe pay for the kids' private school and deduct that from the maintenance or the child support. And then I can't count the amount for maintenance or child support because it wasn't actually paid in full. I see mistake after mistake.
Yeah,
Yeah.
the qualification of a mortgage, this is an area that I would put up with taxes. It is also the kind of aspects of financial advice I will give. I'll walk my client and be like, listen, you're going to get X and like, if you're going to keep the house and it is all of your net worth in your house, that's not financially prudent because you have very little wiggle room but it's like a soft kind of guidance. But I think a lot of people, the point I'm trying to make is that no one would ever criticize me for lacking confidence. And I feel like there are areas where clients come to me and they don't understand that I say, you need to go talk to a lender or someone specific, and you need to talk with your accountant, or you need to talk with your CPA about this. And they're like, don't you know everything? And I'm like, I talk like I know everything, but there is a limitation and divorce lawyers, we are often the quarterback. We have business valuation experts, we have mental health, we have counselors, and we identify issues and then bring in experts like you. And this is that area that I think is so overlooked by so many divorce lawyers. They don't really identify the issue in the first place of, hey, you might have a problem or you need to go see an expert on this particular issue. I think people, when their client comes to them and they say they might be drunk or they might have a substance abuse problem, to say you need to go get a specialist or you need some help here. I think a lot of divorce lawyers, that's pretty easily presentable. When someone says, Eric is, okay, I want to buy a house, not as many divorce lawyers as should say you should go seek a specialist on this.
Yeah. And I think the other thing too is you guys figure income very differently than we do,
Yeah.
like night and day. So you might think that you're setting, let's take Melanie and Eric, for example. If Melanie's going to keep the house and Eric's going to be paying her $25,000 a month in support, how could she not qualify to refinance or assume the home loan if the payment's only $3,500 a month, right? And so then if you write something in there saying she has to have the assumption done within 60 days of final decree or she has to sell the house, it's not possible because she hasn't received the support for long enough, right? Or just figuring out income in general. Maybe Melanie's self-employed and you're coming up with income of 15 grand a month. But when we dig in, we're coming up with 200 a month, like $200 a month.
Yeah.
So I think that those are just the big differences where what we do isn't really common sense. We have these guidelines that are so strict. Not me that's loaning the money. So we have to follow them.
Indeed. Carla, it's super informative. Thank you for the time
Thank you.
and information. For people that want to learn more about you and your team, where's the best place for them to find you and how can they get in touch with you?
Yeah, there's a couple of different places. So our main phone number is 303-525-9077. You can email me at kkyte, so it's KKYTE at mydivorcemortgageplanning.com, all spelled out. You can Google me, Karla Kyte. You can find me all over online. I'm pretty out there. I'm pretty easy to find. I really hope that the attorneys that are listening, and I know a lot of attorneys listen to this because that's how I was told about it. I really hope that they see a value in bringing in a CDLP to help with the cases and just taking that burden off of themselves. I think that's the main thing. But thank you.
It's something that I'm gonna do a better job of in the future. But I've talked about bringing in financial advisors and having a divorce coach, the mental health in the right circumstance, making sure that you really have a team and people. I think they don't understand how important that is. It's during especially divorce lawyers, we go through it and it's not our divorce. I mean, it's a stressful job that we do, but it kind of pales in comparison to what the client is actually going through. And having people that have answers and making sure they're seeing stuff ahead of time is really one of the critical elements of what a divorce lawyer does. But we don't have all the answers.
Yeah.
So no, Carla, thank you so much.
Yeah.
And I encourage people. We'll have a link to your bio and email and phone number in the show notes. But until next time, thanks for joining us on Divorce Altitude.
Thank you.